Morning to all of you. I am very deeply obliged to the Honorable the Chief Justice for having given me this opportunity to visit your lovely state, one of the most picturesque and most beautiful states of our country. I am also very obliged to His Lordship for giving me the opportunity to be a part of this program. I am very grateful to the learned director of the Sikkim Judicial Academy for the great attention that he has paid to every detail and the care with which he has set up this program. His team has done a brilliant job and I am very grateful to him. And finally, I am very humbled by your presence, because after all, the Constitution and the laws are conceived of by the executive. They are enacted by the legislature. But it is you who interpret and live and breathe the Constitution and the laws. We who are on the other side and face you every day in court, we only assist you. And today also my endeavor will be only to assist to the very little extent that I know with regard to these two aspects that we are required to deliberate today. The first half being with regard to the Constitution, and the second half being with regard to a new law which has come into being, the Commercial Courts Act. In my view, perhaps a more detailed exposition on the Commercial Courts Act is required than of the Constitution, because the Constitution is a tapestry with which you all are dealing with every day, more than me. I will give a few tidbits of what I feel are important, and then we can go on to the more interesting part of the day's discussion, which is the Commercial Courts Act. To begin with the Constitution, if I may say that the Constitution is really an embodiment of what our founding fathers thought should be the way that we lead our life. I will put it in this fashion, that the Constitution is really our dharma. India redeemed its pledge regarding its tryst with destiny on the stroke of the midnight hour of 15th of August 1947. And as you all know, while the world slept, India awoke to light and freedom. At the midnight hour, a new star rose, that was the star of freedom in the east. A new hope came into being and a vision long cherished materialized. The Constitution of India was adopted by the Constituent Assembly on the 26th of November 1949 and became effective from the 26th of January 1950. A little bit of trivia about the Constitution before we go on to serious aspects of it. The Constitution is the longest written constitution of any country in the world. Both its Hindi and its English versions were handwritten. The Constitution took 2 years, 11 months and 18 days to be written by hand. Each page of the Constitution, and this is where a little bit of Bengal comes in, and I become a little parochial in this regard. Each page of the Constitution is decorated by artists from Shantiniketan, led by one of our greatest painters, Nandalal Bose, and his team comprising of Beohar and Ram Manohar Sinha. The calligrapher who wrote the Constitution, this brilliant handwriting, was Prem Bihari Narayan Rasda. The Constitution was published in Dehradun and is photolithographed by the Survey of India. The production took 5 years, and the original Constitution, very interestingly, is kept in a special helium-filled case in the Indian Parliament. One another trivia about the Constitution It's well known and it's well recognized. And we say quite frequently that the father of the Constitution is late Dr. Ambedkar. There is no doubt that Dr. Ambedkar played a pivotal role. But when we have any discussion about the Constitution, in my very respectful view, the contribution of one man is a little forgotten and unfortunately. And I would like to pay my regard to this gentleman who, in the view of all, including Dr. Ambedkar, was really the man who was the spirit behind the drafting of the Constitution, that is Sir B.N. Rao. There again I bring in a little bit of Bengal. Sir B.N. Rao was the judge of the Calcutta High Court. He became a temporary judge on the 2nd of April 1935 and a permanent judge on the 16th of January 1939. He continued as a judge of the Calcutta High Court till 1st of February 1944. Sir B.N. Rao, whose full name was Sir Benegal Narsingh Rao, he in fact was the first Indian judge on the International Court of Justice in Hague. But so far as this Constitution is concerned, let me quote what Dr. Ambedkar said about Sir B.N. Rao's Constitution. Dr. B.R. Ambedkar, in his concluding speech in the Constituent Assembly on 25th November 1949, said this: "The credit that is given to me does not really belong to me. It belongs partly to Sir B.N. Rao, the constitutional advisor to the Constituent Assembly, who prepared the rough draft of the Constitution for the consideration of the drafting committee." Insofar as Sir Rao's draft is concerned, it consisted of 243 articles and 13 schedules, which ultimately, on the day it was originally enacted, became 395 articles and 8 schedules after discussions. Now this Constitution, which was enacted by the Parliament, has formed the founding basis for the way we live, the way we breathe, and the way we are expected to act in our daily lives. Is the Constitution really what it was? I'm sure you all have all heard of the classical allegory of the ship of Theseus. Let me give a brief idea to what it is. In the olden days, the ships were made of wooden planks. Each wooden plank could be laid one after the other and they would be put in place. As the ship sailed on the seas over years, the wooden planks would not be maintained in their original condition and they would naturally have to be replaced because of the corrosion caused due to the sea. The question is, as each of the planks are replaced one after the other, ultimately when all the planks are replaced, is it the same ship or is it a new ship? The ship which started out from the port with the original planks, they've all been replaced. Then does it continue to be the same ship? To bring in the metaphor of the human body, our cells are dying every day and fresh cells are being replicated and created and formed. Are we then the same human being? It's a little philosophical. But we are what we are. The ship remained what it was only because its essence remained the same. Insofar as the Constitution is concerned, the Constitution has been in existence for 74 years, from 1950 to 2024, 74 years. You all know that the Constitution has been amended 106 times. 74 years, 106 amendments. A mathematician will tell you that it's more than 1.5 amendments a year. So is it really the same Constitution? Or are we today dealing with a different Constitution? We have the essence of the same constitution because of what is known in legal doctrine as the basic structure of the constitution. And if the judiciary had not held that the basic structure of the constitution cannot be touched, cannot be amended, cannot be changed, as was endeavored to do by the political dispensation, today really we may have had a new constitution. Without much ado, let me go into this aspect of the matter which I feel is really interesting and something which is beyond what we deal on daily basis. I hope this works. How do I change the slide? This is the preamble to the constitution which was there on the day the constitution came into being. Is it readable and legible? A question, it's not a trick question, a question which students of law are asked to answer. Is this the same preamble that we have today? If not, why? Does it appear to be different from what we have today, or is it the same? Now let's go to the next slide and see what it now is. Come in on the third lines. Socialist and secular. Another addition in the portion which reads as fraternity. Fraternity assuring the dignity of the individual and the unity and integrity. Please see what it was before. You will find integrity was not there. These changes have come about by the 42nd Amendment of the Constitution. Let's see, this is what it is now. Sovereign Socialist Secular Democratic Republic. It was earlier only Sovereign Democratic Republic. And the second aspect is here, there is no integrity. There is just the unity. Now we have the unity and integrity of the nation. So this is just an example of what the amendment does to the constitution. It brings in new concepts, new features, new policies, retaining the spirit and essence of the old, but bringing in the new, because the old order must change, yielding place to new. Today there is a lot of talk about the constitution being revisited. We've revisited the constitution 106 times. And cut out the most important features of the changes that have taken place over the last 74 years. I hope these are audible because it's not very audible to me from here, but I hope they're visible and legible up there. The First Amendment, please see, are they readable? I'll just try and summarize what they are. Our Constitution came into being in 1950. The First Amendment was within the year 1951. And this enabled the state to make provisions for the advancement of socially and backward classes. Then a ninth schedule was added. I don't know if it's visible there. A ninth schedule was added. If you see the ninth schedule to the Constitution, you will find that this schedule comes in terms of Article 31B, the Article 31 capital B of the Constitution, and it validates 284 statutes which have come into being from time to time, and it provides that nothing would affect the validity of these 284 statutes. These statutes have been added from time to time over the period of time, but the ninth schedule came into being by way of this First Amendment to ensure that the constitutional vires of these statutes were not challenged. Very importantly and very interestingly, Article 19, which is part of the fundamental rights in Part 3 and the backbone of the fundamental rights, that was amended. And 3 additional reasonable restrictions were added. As you are aware, so far as Article 19, that is freedom of speech and expression, is not an unrestricted right. It is not unqualified, but it is subject to reasonable restrictions. Certain restrictions were already there. 3 further restrictions were added when one cannot take recourse to say whatever one wants to. One is public order, very important, public order. Second is friendly relations with foreign states, and thirdly is incitement to an offence. Maybe the second of these is something which we don't deal with on a daily basis, but the first 2, public order and incitement to an offence, is something which one sees on a regular basis coming to courts. The defence taken by the accused, defence taken by the person who is accused of acting in violation of Article 19 is that I have the right under Article 19(1), freedom of speech and expression. The defence, the stand of the state is you have the right but subject to reasonable restrictions, and you can't do anything which is violative of public order. You can't create chaos on the streets. You can't act in a way which might lead somebody to do an offence or induce or incite an offence. These restrictions were also made reasonable and justifiable. Then we have the second amendment the very next year, 1952. Not very important, but they allowed representation to the Lok Sabha to be readjusted. Then the 7th amendment is very interesting. 7th amendment allowed a common high court for more than 2 states. One may think why this is important, but in the northeast of India, we had the 7 sisters, all the states sharing one high court initially. So this had to be done by way of a constitutional amendment. Recently, as you are aware, new states came into being, like Telangana from the old Andhra Pradesh, Chhattisgarh from the old Madhya Pradesh. So when these states were coming into being, the high courts had not been set up. High courts were set up after the reorganization acts came into being and were enacted. So initially during this transitional period, the common high court would act as the high court for 2 states. We still have the Punjab and Haryana high court acting for both Punjab and Haryana. Initially we had the high court in Hyderabad acting as the high court for Hyderabad, Andhra Pradesh and Telangana. We had the high court in Guwahati acting as the high court of several states in the northeast. So this was required. The 7th amendment was required to take care of this situation. Then we had the introduction of union territories by the 7th amendment. So there are several union territories, as you are aware. Then another important one is the 9th amendment, which related to adjustment of territories in 1960 between India and Pakistan. Then the 10th amendment, the territory of Dadar, Nagar and Haveli were added in. Skipping through the next few amendments, perhaps the next amendment is the 25th amendment. Is the 25th amendment showing on this slide? Or have we passed it? It's, I think, somewhere there. The 25th amendment is extremely important so far as our courts are concerned and we are concerned. Because by reason of the 25th amendment, one of our fundamental rights were abrogated. The right to property was a fundamental right. So a citizen had a fundamental right to property. That was deleted, and right to property is now only a constitutional right under Article 300 capital A. It is no more a fundamental right. So this is very important amendment brought in by this amendment. 26th amendment in 1971 is equally important because a very, very controversial and prickly and thorny issue was resolved by this when privy purses were abolished. privy purses of the former rulers who were ruling the princely states, extremely rich princely states, who were ruling as Nawabs and Nizams and Maharajas during the British era, primarily controlled by the British but still enjoying huge amount of resources. Their privy purses were abolished by this amendment, which took place in 1971. 35th Amendment is very important so far as all of you are concerned. By this 35th Amendment, this Sikkim became an associate state of the country. From being a protectorate state, it became an associate state. But the deed was only half done. Therefore, by the next amendment, which is the 36th Amendment, I don't know if it's done, or in the slide has stopped, full-fledged state. Then we come to the 42nd Amendment, which took place in 1976. If you remember, 1976 was in the midst of the emergency. 42nd Amendment is known as the mini constitution because so many amendments took place during this time. One of the amendments is something which we've already gone through, the amendment to the preamble, by which socialist and secular were added, integrity was added. The second aspect of the 42nd Amendment was the 7th schedule. 5 subjects were transferred from the state list to the concurrent list. Important subjects: education, forests, weights and measures, wildlife, animals and birds, and administration of justice. Transfer from the state list to the concurrent list meant now the center also had the right to create laws and was not exclusively reserved by virtue of Article 246 to the state. So now the center steps in and creeps into the domain of what was earlier on exclusively the state's domain. Very important changes so far as the parliament is concerned. By this amendment, the president was made bound to act on the advice of the cabinet. Secondly, center was allowed to deploy central forces in a state to deal with situations of law and order. Discretionary powers were given to the speaker and the prime minister, and directive principles were given precedence over fundamental rights. But the most important aspect of the 42nd Amendment with which we are concerned is the next portion, which is the curtailment of the power of judicial review of courts. This no longer exists, but by this amendment, this union wanted to bring in a feature by which judicial review was curtailed insofar as the law by the 42nd Amendment made the power of the Parliament supreme over that of the courts. Very important addition was Part 15, Part 14 capital A and the directive principles of state policy. As you are aware, in Part 14A, two articles were added in. One is the power to form administrative tribunals, which is now a part of daily life so far as lawyers and judges are concerned. Administrative tribunals, whether so far as dealing with their service jurisprudence. And that's Article 323A and 323B, a lot of tribunals were brought in on various subjects. So now started what was known as the tribunalization of justice, curtailing the power of the High Court, transferring powers from the High Court to tribunals set up under the Constitution. Earlier on, there was no power of judicial review in the High Courts by reason of this amendment. Then came in the judgment of the Honorable Supreme Court in L. Chandrakumar, which said that these tribunals cannot act uncurtailed, unfettered and unbridled. So all orders of these tribunals, whether it be the administrative tribunal, the land tribunal, the taxation tribunal, etc., all these tribunals were made subject to judicial review by the High Court. And the High Court's division bench now sits as the first court of the High Court, but in judicial review of orders of the tribunal. What it essentially does is that it reduces one layer, takes up the work of the single judge of the High Court and really transfers it to the tribunal. So instead of the learned single judge, then the division bench, then the Supreme Court, the third tier or the lowest tier now becomes the tribunal. So from the tribunal it goes to the division bench and then to the Supreme Court. So the lowest rung of the High Court is only dispensed with. Essentially it's just old wine in a new bottle. The citizen still has 3 tiers, a hierarchy of 3 levels, but the lowest tier, which was the High Court single judge, is now done away with, and we have the tribunal. So this is the 42nd Amendment essentially. And the next important issue is the 52nd Amendment. 52nd Amendment is not something that we lawyers and judges usually deal with. Perhaps 52nd Amendment is not something which you all have dealt with. But recently 52nd Amendment took up a lot of time of the Honorable Supreme Court. It relates to anti-defection law. And the state in Maharashtra, the state of affairs in Maharashtra, with one party taking over control of another party legislatures and then taking over the government, that took up a lot of time of the Supreme Court with regard to the state of affairs in Maharashtra recently. And a judgment has been delivered by the Supreme Court very recently on anti-defection law based on the 10th schedule, which was brought in by this 52nd Amendment. Then we have the 65th Amendment by which National Commission for Scheduled Castes and Scheduled Tribes was established. 69th Amendment, the Union Territory of Delhi was given the status of a national territory of Delhi. 73rd Amendment, Panchayat Raj was established. 86th Amendment, education was made a right, fundamental right, elementary education. 97th Amendment, cooperative societies was given constitutional rights. 101st Amendment was something which very often we deal with, that is the GST regime came into being, the Goods and Services Tax Act, the GST regime came into being. 102nd Amendment, constitutional status was given to the National Commission for Backward Castes. And finally 106th Amendment, which took place last year, women's reservation was given to the Lok Sabha by way of 1/3 of all seats being reserved in the Lok Sabha for women. So this really takes us through all the important amendments which have, although they keep the essence, but have substantially added to the flavor of what originally was the Constitution. But the Constitution would not have been what it is today had it not been for the very active, rather proactive role undertaken by the Honorable Supreme Court. And insofar as the proactive role is concerned, as I had mentioned, the constitutional amendment started within the year itself. And the first attempt by the Parliament to ensure that the powers shifted from the Supreme Court and the constitutional courts in the states, that is the high courts, to the Parliament started in 1951 itself. And the first important judgment of the Supreme Court in this regard is the case of Shankari Prasad versus Union of India. In Shankari Prasad versus Union of India in 1951, the Supreme Court held that the Parliament has the power to amend any part of the Constitution, including fundamental rights. So within the year of the fundamental rights, part 3 of the Constitution coming into being, there was an attempt at encroachment and the Supreme Court agreed that fundamental rights can be amended. This was followed in 1965 by Sajjan Singh versus State of Rajasthan, where the Supreme Court agreed with the view of Shankari Prasad and held that in view of Article 368, Parliament could amend any part of the Constitution. Article 368 is very interesting. If I may just read Article 368 for the benefit of all of you. The heading says power of Parliament to amend the Constitution and the procedures therefore. It says notwithstanding anything in this Constitution. So it starts with the non-obstante clause, giving it overriding powers over anything inconsistent or repugnant anywhere else in the Constitution. Notwithstanding anything in this Constitution, Parliament may, in exercise of its constituent power, amend by way of addition, variation or repeal any provision of this Constitution in accordance with the procedure laid down in this article. So there was, it appeared, manifestly a power to make amendments to the Constitution. Had it not been for the basic structure doctrine, it would have been within the power of the legislature to wholly and completely obliterate what we originally had as the Constitution. And the original few judgments did recognize this power. As I said, right up to 1965, Sajjan Singh's case recognized the power of the Parliament to make amendments to any part of the Constitution. Then came the famous case which all of us have studied as students, Golaknath. Golaknath was the state of Punjab, that was 1967. Golaknath overturned Shankari Prasad and held that 368 does not set down the substantive law but only lays down the provision or the procedure by which the amendments are to be carried out and does not give absolute power to the Parliament to amend anything that it wants. So a divergence was sought to be made in Golaknath which said that Shankari Prasad was wrong because Shankari Prasad said Parliament can amend anything and everything. Golaknath said no, Shankari Prasad deals with Article 368. 368 only lays down the procedure, does not lay down the substantive law that anything and everything can be amended. To surpass and to overrule and to ensure Golaknath's case, which redeemed the position somewhat and left the power of amendment outside the bounds of the legislature and the Parliament came forward with the 24th Constitutional Amendment. The 24th Constitutional Amendment of 1971, during those troubled times, attempted by the government to straightaway override the Supreme Court. And the government introduced a provision in Article 368. If you come back to Article 368 now, you will find something which I did not read when I placed 368 at the outset. There is a bracket which shows when this amendment came about, which says that it came about by the 24th Amendment of 1971. I am sure all the constitutions that you have say it. So this came about by reason of the legislature stepping in to override directly the Supreme Court's judgment, to give power to the Supreme Court to amend any part of the Constitution. And it made obligatory the President's assent to be given to the constitutional amendment bills. This was 1971. Troubled times, 1973. Golaknath was delivered by a bench which constituted of 11 judges. Till then it was unheard. 11 judges. And it was a fractured majority of 6:5. A wafer thin majority of Golaknath was sought to be ridden by this constitutional amendment. 1973 came Keshavnath Bharti. 1973 was a larger bench. 1973, the bench of 13 judges of Golaknath, the 11 judges of Golaknath became 13 judges. And again a wafer thin majority of 7:6. It is in Keshavnath Bharti that the first time the concept of the doctrine of the basic structure of the Constitution and the Supreme Court's directive that hands off the basic structure came in Keshavnath Bharti. interestingly, so far as Keshavdan Bharati is concerned, Keshavdan Bharati had a very checkered history by reason of this having resulted in the fate of 3 or 4 judges of the Supreme Court who were later on expected to become Chief Justices of the Supreme Court of India being changed. We will not go into that aspect of the matter. But Keshavdan Bharati's judgment also did not remain as it stood without attempt at government interference. The government came by this 42nd Amendment, which I had mentioned earlier. By the 42nd Amendment, the government declared that no limitation could be brought on the government's power or the constituent power of the parliament. So Article 368's power to revisit and revise the constitution was again brought in by the 42nd Amendment. Then came another very important judgment, which is the Minerva Mills case. The Minerva Mills case of 1980. Minerva Mills case is important because by this judgment, the Supreme Court invalidated the provisions of the 42nd Amendment to the extent that they sought to abrogate the law laid down by Keshavdan Bharati. Then we have a series of judgments right till date, right till 2024, which have held that the basic structure of the Constitution is something which cannot be touched, which cannot be invalidated, and which is supreme. So the question that we are faced with is, what is the basic structure? Is it ethereal? Is it something that we can touch? Is it something tangible? Is it cast in stone? Is it to be found somewhere in the Constitution? The Supreme Court says it's difficult to lay down by way of a formula as to what would be the basic structure. Come to us with a case and we will say whether this is part of the basic structure or not. So the concept of basic structure has changed over the years, and different judgments have added to the concept of basic structure. The basic structure, or what are the components of basic structure, have evolved with different judgments. So far as basic structure doctrine is concerned, if I may just tabulate what are the basic structure components which have been laid down by the Supreme Court, is really very obvious. Supremacy of the Constitution has to be. Sovereign democratic republic nature of the country, the body politic, the way in which our democracy is designed, the secular nature of the Constitution, separation of powers between the legislature, the executive and the judiciary, the federal character of the Constitution, the unity and integrity of the country, welfare state, parliamentary system, rule of law, harmony and balance between fundamental rights and the directive principles of state policy, principles of equality, free and fair elections, independence of the judiciary, limited power of Parliament to amend Constitution, powers of the Supreme Court under Article 132, 141 and 142, power of the Constitution under Article 136, so special leave petitions, powers of the High Court under Article 226 and 227. These are some of the concepts and components of what is basic structure, and these have been held to be inviolable. These cannot be touched. Now there is a lot of talk as to what are those aspects of the Constitution that are of prime importance and essence to us as lawyers when we come before your courts, and which are those aspects that judicial officers need to deal with on regular basis. Of course, this must necessarily mean the fundamental rights. There are several fundamental rights which are to be found in Part 3 of the Constitution, which starts with Article 12, which really defines what is the state, what is the instrumentality. And 13 onwards, 13 is the restriction on the state not to make any law which takes away or abridges the fundamental rights, or to make any law which is in contravention of the fundamental rights. So it is by reason of Article 13 that the supremacy of the fundamental rights over everything and anything else comes to the fore. Article 13, if I may place this provision for your convenience, the state shall not make any law which takes away or abridges the rights conferred by this part, which is Part 3 of the Constitution, which is the part relating to fundamental rights, or any law made in contravention of this clause shall, to the extent of the contravention, be void. This leads us to Articles 14, 15, 16, 17, 18, 19, 20, 21, etc. Article 14 is of prime importance to all of us, as whether we are on the bar or on the bench, which is the right of equality before law. Article 14 says that the state shall not deny any person equality before the law or the equal protection of the laws within the territory of India. One confusion which arises is, does Article 14 apply to private citizens in litigations between private entities and arising out of private contracts? Very often we find lawyers arguing principles of Article 14 of non-discrimination, of non-arbitrariness, of fairness in private disputes. The Constitution makes it clear that the right is conferred on persons when they are pitted against the state, and the concept does not apply to private litigations where the parties' rights are decided in terms of the private agreement between the parties. Insofar as rights where private parties are concerned, between one person and another, one person and a company, two companies, a company and different other entities, principles of the Contract Act, Specific Relief Act, Transfer of Property Act, Sale of Goods Act, they would apply, not constitutional principles of Article 14. Which is very often we find that when tenders are issued by the state, with regard to different aspects of construction contracts, with regard to different development work, they are challenged in court on the anvil of Article 14. Similar tenders issued by private bodies cannot be challenged. Service jurisprudence, where Article 14 steps in, when one has to give a right of hearing, orders have to be reasoned, there have to be speaking orders. These principles are principles applicable to positions when the state is pitted against a private citizen. Whether it be with regard to administrative decisions, whether it be compassionate appointments, judicial review, concepts of no work, no pay, concepts in service jurisprudence, these are all part of Article 14. It says equality before the law. The courts have expanded it to mean that one must not be arbitrary, one must not be discriminatory. There is a duty to give reasons and duty to follow principles of natural justice. Principles of natural justice, as you all know, have two limbs. One is no man can be condemned unheard, right of hearing. And secondly is no man can be a judge in one's own cause. These are branched up into different situations, but essentially all come out of these two concepts. Equality is essentially a concept which envisages these two principles of natural justice. No man can be condemned unheard, which now the Supreme Court says is to be incorporated even in provisions where it is not there. In fact, Supreme Court has gone to the extent of saying that even when charges are framed, an opportunity of hearing has to be given to the accused. So these are concepts which are now transgressing, or not transgressing rather, which are being incorporated into every branch of jurisprudence where the state is concerned. Then we have Article 15. Article 15 is prohibition on discrimination on the grounds of religion, race, caste, sex or place of birth. Very important provision is Article 16, which is equality of opportunity in public employment. 16 is something which is utilized on a day-to-day basis, because public employment is one of the most important aspects of litigation which involves the state. And there any lack of equality insofar as matters of public employment on these aspects mentioned in Article 16 would immediately be set aside by courts. Article 17 is untouchability, which now really is not something we deal with on a day-to-day basis. Article 18 is abolition of titles. No prefixes, no suffixes. Though gone are the days when we had the concepts of Sir and Rai Bahadur and Maharaj and Nizams and etc. Come to the most important article, most important part of the fundamental rights, Articles 19 and 21. 19 is protection of rights, and they have been classified into several aspects: speech and expression, right to assemble peacefully, peaceably and without arms, right to form associations, right to move freely and right to reside. Important is that all of them are curtailed by reasonable restrictions. If you see Article 19, sub-article 2, you would find the three aspects which I had mentioned were brought in by the 1951 amendment. Public order is mentioned, friendly relations between states is mentioned, and incitement to offence is mentioned. They were brought in by the first amendment itself. Article 19 is of prime importance because right to speech and expression, and G, right to practice any profession or to carry on any occupation, trade or business, forms a very important aspects of the litigation that is generated in high courts under Article 226 of the Constitution by way of writ petitions, where the right to carry on trade or business is usually impinged by the state, and one is then required to approach the constitutional courts to have those rights confirmed and to get relief on that basis. Article 21 is the right of life and personal liberty. No person shall be deprived of life or personal liberty except according to procedure established by law. It says so little. It's a sentence with perhaps 10 or 12 words, no more. But it says so much. Everything now has been brought within the sphere of Article 21. Whether it is the right to get anticipatory bail and not for a limited period, whether it is a right not to be arrested, whether it is a right to pre-trial release on bonds, whether it is a right to get protection from custodial harassment, whether it's a right to get protection from eve-teasing, whether it is a right to get fair procedure and fair trial, whether it is a right to get protection against fake encounters by the police, right to foreign travel. Why I mentioned foreign travel is now the banks and financial institutions have come up with this device of issuing lookout circulars against defaulters and stopping them when they try to leave the country. The Supreme Court says, no, right to go abroad is a part of right to life. Right not to be handcuffed. Right to be treated essentially with dignity as a human being. Everything has been brought within its ambit. Right to privacy. Supreme Court now says right to privacy is a part of right to life. So whatever rights one thinks of as a human being, as apart from the degraded existence of an animal, is part of Article 21. It is essentially that which recognizes us and human beings and gives us the right to assert everything that falls within the contours of being a human being, a full-fledged human being with complete dignity and no deprivation of whatever are the contours and the boundary limits of being a human being. So this is a very important aspect of the fundamental rights, and often you would find public interest litigations based on Article 21, whether it be with regard to rights of slum dwellers, whether it be with regard to environmental concerns, all part of the activism which is being shown by the judiciary with regard to enforcement of Article 21 rights. In my respectful view, Article 19 and Article 21 are the backbones of our Constitution. But so far as criminal jurisprudence is concerned, apart from Article 14 and Article 21, which enters into every artery and every vein of criminal jurisprudence, one article about which I have not yet spoken is also of prime importance. That is Article 20. I would like to take some of your time on Article 20 because I believe this has substantial impact so far as criminal jurisprudence is concerned. The concepts that we have, that there cannot be double jeopardy. For the same offence, I cannot be made to suffer twice. Secondly, I cannot be made to be a witness against myself. Very often now, the courts come up with this statement by the investigating agencies that the witness is not cooperating. While detaining the witness, we are detaining the accused or the witness. Witness can be detained, but only after they brought in as a accused. If they are brought in as a witness and then detained, that the Supreme Court has frowned against. But why have you detained the accused? Because he is not cooperating during investigation. What is he supposed to cooperate? Admit his guilt. He has a constitutional right, a fundamental right to maintain silence. You cannot compel him to be a witness against himself. And that is recognized by Article 20. If I may place Article 20, protection in respect of conviction for offences. No person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence. This is a very interesting concept. Today, a particular act is not statutorily recognized as an offence, either under the Indian Penal Code, the name of which is very soon to change from July, and we have an entirely new code. It's very difficult to even pronounce the name. So I continue to say it's a new law. I don't know how we are all going to go through this new law. The entire arrangement of sections have changed. Concepts have completely now become different. Whatever we've learned from our days of being a student, we have to unlearn. Both with regard to the Indian Penal Code, the Criminal Procedure Code and the Evidence Act, we have to unlearn everything that we have learned. It's a good time to actually retire. But suppose a particular offence is not statutorily recognized in the existing law as an offence. The person cannot be convicted of such an offence if on the date he committed that act it was not an offence. There's a very interesting series on, I think it's on Amazon, called the Tokyo Trials. I don't know if you all have heard of the Tokyo Trials. After the World War, there were two big trials which were held by the winners naturally in order to send the losers into ignominy. One was the Nuremberg trials, which were held against the perpetrators of the crime in the World War II, that is the German perpetrators, particularly Nazis. So that was held in Nuremberg. The second trial was against the perpetrators in in the East, that is the Tokyo trials. The purpose being both that we will have a show or a facade of how European justice is meted out, and we will hold them guilty of the offence of having waged war against humanity. Now, so far as the Nuremberg trials were concerned, the trial was held earlier in point of time, and the conviction was given against all the perpetrators, the German perpetrators, and they were held guilty of having waged war against humanity. Interestingly, prior to the Nuremberg trials, this concept of waging war against humanity did not exist. You could wage war against your own monarch, or you could commit offences as codified under your local laws. The concept of war against humanity was an unheard of concept. It was designed and made into law only at the Nuremberg trials. When the Tokyo trials took place, the attempt by the European judges was to hold the Japanese guilty of the same crime, war against humanity. Of all the judges, there was one judge from India. Again, I go back to my native land, Bengal, Dr. Radha Vinod Pal. He was a solitary judge from India who was part of the panel of judges. He said this can't be done. You may hold them guilty of whatever offences you want, but this is a crime, this is an offence which did not exist as a crime on the date when the offence was committed. So you can't hold them guilty of this offence, because this offence came into being and was conceptualized only after the war had ended. So if today I am committing an act of stealing this, and stealing this is not an offence today when I am committing the act, how do you hold me guilty of that offence? So his was the lone dissenting voice in the Tokyo trials. It's a very nice serial on Amazon Prime or Netflix. You get a chance, watch it. His lone dissenting judgment, of course, now has been recognized as one of the universal principles of international jurisprudence. There's a statue made of him in Japan. But this concept is Article 21, 20 sub-Article 1. No person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under law in force at the time of the commission of the offence. At the time when the offence is committed, the punishment was 7 years. Later during the course of the trial, there is an amendment and it becomes 10 years. But when he committed the offence, it was 7 years. He can't be charged for the same offence for a penalty which is more than what existed when he committed the crime. Then 2, no person shall be prosecuted and punished for the same offence more than once. So if I have committed one offence which is punishable under different sections of the statute, I must be punished once, which is why we have the concept of overlapping punishments. It's not that I have 10 years here, 10 years here, you add up and make it 20 years. Or I am punished, I am convicted, and then there is a retrial, I am convicted all over again. Then 3, no person accused of any offence shall be compelled to be witness against himself. The right to remain silent. I am called by the Enforcement Directorate under the PMLA, which appears to be the most important investigating agency, or maybe the CBI or any other investigating agency, and I remain quiet. And then I am arrested, and when my bail application comes up, the lawyer for the CBI or the ED or the investigating agency, state investigating agency or the union investigating agency says he is not cooperating. To cooperate would be to act in violation of my fundamental right. Can't force me to give evidence against myself. This Article 20 is of substantial importance insofar as criminal jurisprudence is concerned in India. This, together with the principles which are culled out from Article 14 and Article 21, form the backdrop of not only constitutional rights and remedies, but also criminal rights and remedies. So far as civil rights and remedies, if it's private litigation between private citizens, constitutional concepts remain at a distance. If it's civil rights and remedies vis-a-vis the state and private citizens, then of course fundamental rights will come in. One other concept I would like to touch upon before we conclude this part of our session. Very interesting distinction has been made in the fundamental rights between who can claim this relief. I just show the article and the distinction will be clear on the face of it. If you have the Constitution, please see how Article 19 starts and how Article 21 starts. It's very interesting and a concept which is a little lost. Article 19 starts by saying all citizens. Article 19(1) says all citizens shall have the right. Now please see Article 21. It is not citizen, it is person. So all the rights except for Article 19, which is related to a citizen, the other rights can be enforced by non-citizens also. So one can have persons who are overseas Indian citizens, foreigners, companies, cooperative societies, partnership firms, enforcing fundamental rights. The oft defense is this fundamental right is not applicable to you because you are not a citizen. Citizens' rights are in Article 19, but the other rights are applicable to everybody who is seeking the protection of the court. Need not be a citizen. I thought this was a very interesting concept which is sometimes glossed over. This is so far as the fundamental rights are concerned. The fundamental rights are followed by the DPSP or the Directive Principles of State Policy and ultimately by the fundamental duties. It's oft said that we Indian citizens are very well aware of our fundamental rights, but we disregard and like to be ignorant of our fundamental duties. And this is applicable to, I think, all of us without any exception. The Constitution puts certain duties on us also to ensure that we leave our country in a better shape than it was than the day when we were born. Every one of us has a right to ensure that the country is a little better than what it was on the day that we were born. So far as fundamental duties are concerned, it's in one article, and please permit me to place this article because it's just one article, and I would just like to emphasize and re-emphasize again and again that this is the backbone of what the Constitution makers wanted us to be. This is what they perceived us human beings to be. Please see Article 51, capital A. Capital A. It shall be the duty of every citizen of India, A, to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. B, to cherish and follow the noble ideals which inspire our national struggle for freedom. C. To uphold and protect the sovereignty, unity and integrity of India. D. To defend the country and render national service when called upon to do so. E. To promote harmony and the spirit of common brotherhood amongst all the people of India, transcending. I cannot emphasize with more this next portion. Transcending religious, linguistic and regional or sectional diversities. To renounce practices derogatory to the dignity of women. Can you permit me to repeat it again? To promote harmony and spirit of common brotherhood amongst all the people of India, transcending religion, linguistic and regional or sectional diversities, to pronounce practices derogatory to the dignity of women, to value and preserve the rich heritage of our composite culture, to protect and improve the natural environment including forests, lakes, rivers and wildlife, and to have compassion for living creatures, to develop the scientific temper, humanism and the spirit of inquiry and reform, to safeguard public property and to abjure violence, to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. Who is a parent or guardian to provide opportunities for education to his child, or as the case may be, or between the age of 6 and 14 years. I beseech everybody, not only in this room, but everywhere outside and myself, to not forget E. This is something which we are at the a point in history which will either make us or break us. We must maintain the spirit of common brotherhood amongst all people, transcending religious, linguistic, regional or sectional diversities. Thank you so much for bearing with me, and I am not very sure how this may have been useful or not, but thank you so much for being so kind to me in hearing me out. Insofar as Courts Act is concerned, do we start that immediately or do we have a short break?
Five minutes.
5 minutes. From the esoteric constitution to the more mundane Commercial Courts Act. Just a query before we begin on this aspect. Do you have the Commercial Courts Bare Acts available? Excellent. And is this a new subject or something that you all have to deal with on a regular basis? Just to...
New.
Excellent. So, on this subject you are where I am, on the same boat and on the same page. So we'll all try and go through this statute together. The statute, the Bare Act, is reasonably thin. It's been made a little thicker by adding in the rules and the directions, etc. But so far as the statute is concerned, it's not that it's very exhaustive, but it has substantial impact. Substantial impact so far as commerce and industry is concerned. And it is one of the statutes which is becoming more and more important day by day as there is increase in commercialization, industry and enterprise in every state. The Commercial Courts Act, you will have noticed, says that it is of 2015. The Commercial Courts Act came into being on the 23rd of October 2015. But this really has had a checkered history. And the checkered history takes us back to 15th of December 2003, that is 12 years before the Act actually came into being. It's surprising to note that the 17th Law Commission of India, in its 188th report, strongly recommended the enactment of a law which gives a fast-track approach to litigation insofar as high-stake litigations are concerned and which deal with commercial aspects by way of making a new legislation. This was way back in 2003 in its 188th report. And the Law Commission noted that the necessity of such a law has come right from the time when in 1991 we had the economic policies of our country being changed. And the new dawn came upon when we tried to modernize our economic approach. And three things have been noted by the Law Commission: privatization, liberalization, and globalization. And the Law Commission noted that if in India we cannot legislatively assure the investors, either domestic or foreign, that we will give them a fast-track approach to adjudication of their claims, nobody would want to do business with India. Already we find, insofar as arbitration is concerned, people are more willing to go to Singapore, more willing to go to London, more willing to go to Geneva, less willing to come to India. So far as litigation is concerned, we must assure them legislatively a fast-track procedure. The Law Commission also went into the aspect of the legislative competence. As you are aware, under Article 246, we have the 7th schedule. The 7th schedule comprises of the Union list, the state list, and the concurrent list. The Law Commission said that there is legislative competence, there is a need to immediately come up with this legislation, and it proposed a model legislation. You know what the government did with it? Nothing. The government did nothing for 6 years after that Law Commission's report. In 2009, there was a conference in New Delhi, which was a conference of the chief ministers and the chief justices of all the states. There in the conference in 2009, on the 16th of August, a resolution was passed that as and when the legislature comes up with such a legislation, we will, the chief justices passed a resolution, we will form the commercial courts and the commercial divisions in our states. It is only thereafter in 2009 that the government introduced an act which is a little different from this act. It was called the Commercial Division of High Courts Bill of 2009. Commercial Division of High Courts Bill 2009, as you know from the name itself, it was restricted to the High Courts. It was passed in the Lok Sabha, it was introduced in the Rajya Sabha, met with immense resistance. The resistance was primarily for two reasons. One is that it was thought that by this legislation, the Parliament wanted to prioritize high-stake commercial litigation, whereas it ought to also have a look at what would be low-cost litigation, the low-stake litigation, which was multifarious and numerically far more. The Rajya Sabha felt, the members felt, that the government was favouring privileged litigants over others. That was the main objection. And the other was that infrastructure and resources of the high courts was insufficient to ensure that this act could be put in place. So because of this strong opposition by members of the Rajya Sabha in 2009, the bill was referred to the Select Committee. I'm sorry, I didn't understand that there was a static interference by reason of the phone. So as I was saying, the bill was referred to the Select Committee. This was 2009. From 2003 we've come to 2009, 6 years. In July 2010, the Select Committee presented its final report. It suggested several changes. The bill was redrafted. It was again introduced in the Rajya Sabha. In the Rajya Sabha, as I'm sure you will say that you can immediately foresee what happened, there was again resistance. There was intense debate and the government felt that it would not be able to go ahead with this bill, and the government withdrew the bill. This was the first innings, as it were, and it remained like this till 2013. In March 2013, the bill, which was a dead letter of the law all this while, was referred once again to the Law Commission. So it was like, as they say, back to the pavilion, starting from scratch all over again. This Law Commission's report was the 253rd report, chaired by former Chief Justice of the Delhi High Court, Justice A.P. Shah. If you remember, the first report was the 188th report, I had said. That was way back in 2003, 188th report. Now we come to the 253rd report. So in the meantime, there have been 65 reports of the Law Commission. So after 65 reports, one goes back to square one and starts all over again. This is perhaps the history of whatever we try and do in India. We have to do it again and again and again to get things defined. So ultimately, the Law Commission in its 253rd report went back to the 188th report's recommendations, reviewed them, revisited them, and suggested another model code. And ultimately, in April 2015, the government introduced an act, which is again not this act, which is known as the Commercial Courts, Commercial Divisions and Appellate Divisions of the High Courts Bill in the Rajya Sabha. You must be thinking, when will we ultimately come to this act? So we are still on another legislation, which is the Commercial Courts, Commercial Divisions and Appellate Divisions of the High Courts Bill in the Rajya Sabha. This bill again faced opposition, and it was referred to the Standing Committee of Personal Public Grievances and Law and Justice. But before the Standing Committee could give its recommendation, by a presidential ordinance, this bill was promulgated. And perhaps that was required, because ultimately this bill perhaps would never have seen the light of the day. So on 23rd October 2015, this bill was promulgated by presidential order. Ultimately, the Standing Committee gave its recommendations. The report of the Standing Committee was tabled. Most of its reports or suggestions and recommendations were ignored, and the Act was passed. It received presidential assent on 31st of December 2015. 31st of December 2015, the ordinance became Act. Within 3 years, in 2018, there was a need for amendment. Several reasons, I'll come to that later. One of the major reasons for the amendment is something we will discuss in a little while. So ultimately, in 2018, we got this Act, which is the Commercial Courts Act 2015, but with the change of name and change in various provisions in this Act. This Commercial Courts Act has its implications and its repercussions in several ways. Now I'm going into the nitty-gritties of the Act. We've had a long gap between when the Act was conceived in 2003 right till 2015, when the Act in its earlier avatar came into being, and ultimately 2018 when its present avatar has come into being and is now existing. Now, so far as the Act is concerned, what does it really do? A, it prescribes a fast-track procedure with fixed timelines. For what? Not all litigations. Two types have to be considered here, or two aspects. One is subject matter, the other is pecuniary. Subject matter, commercial disputes, and peculiarly, it was originally in the 2015 Act 1 crore. Now it has been brought down to a much more unreasonable figure, I say unreasonable figure of 3 lakhs. I say unreasonable figure why? When the Act was conceived in 2003, it was meant to aid high-stake litigation get a fast-track procedure, which is why originally it was 1 crore. 3 lakhs is no more high-stake litigation. But then what we have is specialized subjects. So when any litigation is instituted in a court, 2 things are to be seen. A is whether the value of the stakes involved, and I immediately come to how we value it, is above 3 lakhs or not. If it is above 3 lakhs, then we have to see whether it is a commercial dispute as defined in the Act. If it is a commercial dispute as defined in the Act and it is above 3 lakhs and odd, then the next thing that we have to see is whether this litigation or the dispute between the parties is something where the plaintiff conceived of an urgent interim relief. If it is not something which requires an urgent interim relief by way of a relief either under Order 39 or Order 40 or Order 38 by way of injunctions, receivers, attachments, etc. If it does not require any urgent interim relief on an immediate basis, then the legislature says you do not have the right to file a suit till you go through a mandatory process of pre-institution mediation. The pre-institution mediation is given a period of 3 months with a further period of an extension, after which you can file a suit if the matter has not been settled. If the matter is settled, then the settlement takes the form of an award as if it's an award under the Arbitration Act, which is the Arbitration and Conciliation Act 1996, and it becomes enforceable as an arbitral award under the Arbitration Act. If the matter is not settled, then the plaintiff has the right to come back to court and file the suit once again. Suppose it was a matter where urgent relief was required, then you don't need to go for the pre-institution mediation. Then you can file it immediately. Then the fast track timelines start immediately. This is the entire scheme of the legislation. Now this legislation also provides for very restricted avenues for aggrieved parties, primarily by way of appeals and revisions. I'll come to these sections in a while, but you may take it from me that one of the most fertile grounds of litigation in civil courts is revisions, either under section 115 of the Civil Procedure Code or Article 227 of the Constitution. Civil revisions are absolutely barred from any order passed under this Act. So also, civil revisions or petitions against any interim orders are barred. And finally, the final nail in the coffin is that appeals can be preferred only from orders which are contemplated under Order 43 of the Civil Procedure Code. Now it may appear that in civil courts it is really Order 43 which lays down the list of orders which are appealable. So what is the difference? The difference is that apart this point does not only relate to the district courts, it also relates to all high courts. Now high courts are governed by the latest patent. One of the clauses of the latest patent is clause 15, this which gives the right to prefer an appeal from any judgment. The moment an order sets out or adjudicates rights of the parties, even at that moment, may not be on final basis, but even on interim basis, it is deemed to be a judgment. So that judgment becomes appealable by way of an intra-court appeal under the latest patent. So that is absolutely barred. So appeals are restricted to Order 43, civil revisions are barred. The next aspect of the matter, and very important, it's a new concept altogether. Summary judgment. Summary judgment under the Civil Procedure Code as we knew it is possibly restricted only to two avenues: judgment upon admission under Order 12 Rule 6 or summary judgment under Order 37. But those are concepts where the admission or the purpose of giving the decree is apparent on the face of it. There is no defense to it. Where except for a moonshine defense, a defense which is absolutely frivolous, no other defense can be made out. And ex debito justitiae, the plaintiff has a right to obtain judgment. But here there are special provisions made under which summary judgment can be given. So this is a very unique concept which is now coming by virtue of amendments being made to the Civil Procedure Code. And the last issue that I will touch upon, very important issue, is the issue of case management. Earlier, as you know, a suit is filed, summons are issued, and then the defendant has a chance to file a written statement. So far as written statement is concerned, there is an amendment to Order 8, there is an amendment to Order 5, as a result of which the defendant is given a chance of 30 days and a maximum period of 120 days, after which the defendant forfeits his right to file a written statement. And thereafter the suit takes its own course. But here, under the Commercial Courts Act, the judge will set up case management hearings. So for everything, whether it be for admission and discovery of documents, whether it be for interrogatories, whether it be for production of documents, whether it be for examination of witnesses, settlement of issues, examination of witnesses, for everything, specific timelines are to be set up. And the timelines are to be complied with. So this is the entire scheme of the statute, where the entire push is towards giving it a fast-track motion. One aspect that we will also deal with, which has generated a lot of litigation, is what is to happen to pending proceedings. Because when the statute came into being, there were hundreds and thousands of cases pending in different courts. So statute says pending proceedings are to be automatically transferred. There is a provision which requires or which enables the suits which are pending on that day or applications on the Arbitration Act which are pending on that day to be automatically transferred. The next question which arises, which again has generated a lot of litigation, is what happens in a situation where the litigant ought to have filed a suit under the Commercial Courts Act because the subject and matter was such that it related to a commercial dispute. But by mistake or intentionally, he has filed it in the regular court. Is it to be transferred in terms of the transfer provision? This has generated a lot of litigation. The reverse situation is also there. It has been deliberately filed in the commercial division or the commercial court to expedite the process, but actually it does not relate to a commercial dispute. How is it to be brought back to the ordinary court? Is it by way of transfer provision? This has generated a lot of litigation, and the answer is it cannot be transferred. There, the Supreme Court has said that the only recourse available is Order 7, Rule 11, rejection of the plaint, or Order 7, Rule 10, give the plaint back with liberty to file afresh. So these are the different aspects on which I try and deal with. But as it is with you, it is with me also a new legislation. So I go a little slow, and because it is the topic is a little verbose, and we have to read a little bit from the sections and a little bit from the judgments. I'll try and keep it as concise and succinct as possible. Now, if the statute is with you, there are two aspects that are of primary importance. One is to decide what is the subject matter which becomes a commercial dispute, and how is one to decide the value involved in the litigation to know whether it comes within the peculiar jurisdiction of the Commercial Courts Act. These are the two primary issues that we have to deal with at the very preliminary stage. The first aspect is how is one to know that it is a commercial dispute. Is any dispute which has a commercial aspect to it a commercial dispute? No. Commercial disputes have been defined specifically in section 2(1)(c) of the Act, and it lays down a list of commercial matters which are enumerated as commercial disputes. If you have a look to the Commercial Courts Act section 2 subsection 1(c), commercial dispute means a dispute arising out of, and it goes on till 22. If I may come back, it means a dispute arising out of. It doesn't say it includes. So this is exhaustive. It is not an inclusive definition. Whatever is here is all that is to be understood as being a commercial dispute, which is known in our terminology as a pigeonhole theory. We have the pigeonholes, either it fits in or not at all. Just like under the Hindu Marriage Act, under the Tenancy Act, whether grounds of divorce or grounds of eviction, it is either there or not there at all. Here too, it will either be a commercial dispute within the meaning of this section or not a commercial dispute. And when you read these definitions of what is a commercial dispute, please keep in mind that it is to be read in a restricted fashion and not in a wide fashion. Supreme Court says to read it in a wide fashion would be to defeat the purpose of the legislation, because the purpose is to give fast-track litigation to only certain specified enumerated sorts of subject matters and not anything and everything. I'll come to an example right away. Let me go through this. 1. Ordinary transactions of merchants, bankers, financiers and traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents. So essentially banking transactions, financial matters, loan agreements. 2. Export or import of merchandise or services. 3. Issues relating to admiralty and maritime law. 4. Aircraft, aircraft engines, aircraft equipment, helicopters, including sale, lease, financing of the same. 5. Carriage of goods. 6. Construction and infrastructure contracts, including tenders. 7. Agreements relating to immovable property used exclusively in trade or commerce. May I pause here for a moment and give an example? Agreements relating to immovable property used exclusively in trade or commerce. Suppose there is an agreement for lease in respect of a particular property. The lessee wants to take the property, develop it and ultimately use it for some business. There is a dispute with the landlord with regard to handing over the property. Would it be a commercial dispute or not? At the very first blush, it appears that perhaps it is a commercial dispute, because it relates to immovable property. It is intended to be used in trade or commerce, but here the catchword is used. Here the Supreme Court steps in, and in this sort of a situation says, when the legislature says used, it means that it is actually being used. So that is how the Supreme Court brings in a restrictive meaning to these words, saying ready to use or likely to be used or taken for the purpose of being used is not enough to bring it within the four corners of a commercial dispute. If the dispute relates to making over of the immovable property, which at that point of time when the plaint was presented was not being exclusively used for trade or commerce, then it is not a commercial dispute. So this is a very clear example of what is the legislative intent. And this judgment is a judgment which goes by the name of Ambalal Sarabhai Enterprises versus KS Infraspace. Ambalal Sarabhai Enterprises, which is reported in 2020, volume 15, Supreme Court cases 585. Ambalal Sarabhai Enterprises, this is KS Infra Space 2020, volume 15, Supreme Court cases 585. This is the factual background of the Ambalal Sarabhai judgment, where it says the property must actually be used. The present user of the property is important, not the contemplated user of the property. While going into this aspect of the matter, in this judgment, the Supreme Court talks of the legislative intent of the statute. And let me place that portion which talks of the legislative intent, because this is what one must keep in mind when one identifies whether a particular dispute is a commercial dispute or not. This is in this judgment, the citation of which I just said, 2020 15 SCC 585. The relevant portion is from paragraph 13. I just placed 3 or 4 lines. Having taken note of the submission, we feel that the very purpose for which the Commercial Courts Act of 2015 has been enacted would be defeated if every other suit, merely because it is filed before the commercial court, is entertained. This is for the reason that the suits which are not actually relating to commercial dispute but being filed merely because of the high value and the intention of seeking early disposal would only clog the system and block the way for the genuine commercial disputes which may have to be entertained by the commercial courts as intended by the lawmakers. In commercial disputes as defined, a special procedure is provided for a class of litigation, and a strict procedure will have to be followed to entertain only that class of litigation in that jurisdiction. If the same is strictly interpreted, it is not as if those excluded will be non-suited without any remedy. The excluded class of litigation will in any event be entertained in the ordinary civil courts, wherein the remedy has always existed. So we have the ordinary system of dispensation of justice, and we have a special class. Having a special class of litigations for a special class of litigants is not something which is anathema to our body politic. We've had that with the Recovery of Debts to the Banks and Financial Institutions Act. We've had that with the Sarkozy Act. We've had with the Insolvency and Bankruptcy Code. We've had this with industrial disputes. This tribunalization of justice is a continuing feature of our body politic. The Supreme Court says we must see that in trying to accommodate litigations which are not commercial disputes, we don't clog the system. Because the other classes of litigations will go to the ordinary courts. But here we are specializing, putting in a special feature by way of fast-track litigations. This is also in line with the concept of the Government of India of the ease of doing business, which the government is trying to promote. In doing that, ordinary litigations should not clog up and block the system. So if we come back to the section which defines what are commercial disputes, we have franchising agreements, distribution and licensing agreements, management and consultancy agreements, joint venture agreements, shareholders agreements, subscription and investment agreements pertaining to services industry, including outsourcing services and financial services, mercantile agency and mercantile usage, partnership agreements, technology development agreements, intellectual property rights, agreement for sale of goods or provision for services, exploitation of oil and gas reserves, insurance and reinsurance, contracts of agency related to any of the above, and please note it uses the word and. That means the list stops here. And in such other commercial disputes as may be notified by the central government. So this is the entire line of disputes. There is an explanation which says that if immovable property is given as security, that it will not cease to be a commercial dispute. That's an explanation. So the first job as a judge is to see whether it is a commercial dispute or not. Or you can do the reverse also and see whether it is above the specified value or not. That is above 3 lakhs or not. Either way, both have to be satisfied. So what is a commercial dispute? Section 2(1)(c) is sufficient. You don't need to go beyond that. Then what is the specified value? The specified value is in subsection I of the same section. Specified value in relation to a commercial dispute shall mean the value of the subject matter in relation to a suit as determined in accordance with section 12. So we have to decide in terms of section 12, then please see the next portion, which shall not be less than rupees 3 lakhs. So it has to be above 3 lakhs. It may be any other figure which the central government may notify, but at the moment it is 3 lakhs. You will find here that it is a substituted provision. It was earlier 1 crore. It has now become 3 lakhs. It has become 3 lakhs because of the government's intention to make fast forward litigation also part of the ease of doing business policy. And that is what the statement of objects and reasons to the amendment also says. So, but 3 lakhs. But how do you decide whether a particular stake in the litigation is 3 lakhs or more? For that, very simple, come to section 12. And section 12, one need not read it, it's very simple. How many types of litigations can there be? There can really be 4 types of litigations. One is for money, one is for movable property, one is for immovable property, and the 4th is for intangible rights. So if it's a suit relating to money, what is the money claimed till the date of institution of the suit? If it's proceedings for movable property, what is the value of the movable property till the date of institution of the suit? What is, if it's for recovery of immovable property, what is the value of that immovable property? The market value till the date of institution of the suit. And what is intangible rights? By intangible rights I mean intellectual property rights, or any other rights which may be which cannot be valued in terms of money immediately. It cannot be. It is something whose money value is not immediately known. There also it is the value as will be assessed by the plaintiff as of the date of institution of the suit. And finally, arbitrations, value of the claim plus value of the counterclaim. If the two add up to this value, then it falls above the specified value, and then it is acceptable as being within the 4 corners of the statute. Therefore, now please come to section 12. This is exactly what it says. Section 12, subsection A relates to recovery of money. B relates to movable property. C relates to immovable property. D relates to intangible property. E says that if there is a counterclaim, counterclaim is to be similarly valued. And finally, subsection 2 is with regard to arbitrations. It is the aggregate value of the claim and the counterclaim. So claim plus counterclaim value. Very simple. So we have these 2 major concepts in hand. What is the specified value? Very easy to find out. After all, it's the plaintiff's assessment. And the plaintiff's assessment is to be taken as correct at the initial stage unless it is palpably absurd. So the specified value we have in mind, and we have the subject matter of the dispute in hand. And if the both fall within the 4 corners of the statute, then it will be a suit which will have to be filed in the commercial court. So far as the litigation coming to the commercial court is concerned, the concept becomes very clear. Now, before I move on to the next topic, there is an interesting rider to this concept, which is interesting, but it's very straightforward. You are aware of the Arbitration and Conciliation Act 1996. The Arbitration and Conciliation Act 1996 says that the court, the competent court of jurisdiction, will be the principal civil court of the district or the High Court. If the suit had been filed, the suit would have been filed in the principal civil court of original jurisdiction in the district. So that is the court of competent jurisdiction insofar as arbitrations are concerned. There is no such limitation insofar as commercial courts are concerned that the Chief Justice of the High Court must designate the district judge's court as the commercial court. There is no such restriction. It is possible for the Chief Justice, the High Court rather, to designate maybe the civil judge senior division as the commercial court. So what happens in case there is a matter which is an arbitration matter and it involves a commercial dispute in terms of section 21C and it is also about the specified limit? Will it go to the commercial court, that is the civil judge senior division or any other judge designated by the High Court? Or will it still go to the district judge because district judge's court is a principal court of original jurisdiction? This appears to be a vexed issue because there appears to be a conflict between the two statutes. Arbitration Act says the lowest court it can go to is the principal civil court of original jurisdiction, never below that. And Commercial Courts Act says it will go to whichever is the commercial court designated by the High Court. This question came up for consideration before the High Court. And thereafter the decision of the High Court ultimately saying that no, the Commercial Courts Act will have precedence when before the Supreme Court. Before the Supreme Court, 3 or 4 concepts and ideas were argued, and ultimately the Supreme Court said that it is the designated court in terms of the Commercial Courts Act which will be the court where that arbitration matter will also go. And why is that? And why will the definition of court in the Arbitration Act be overridden and be ignored? Number of reasons, and quite valid reasons. The first is the Arbitration Act is of 1996. The Commercial Courts Act is of 2015. When the Parliament makes a later legislation, it is deemed to have knowledge of what was the existing law. So knowing the existing law, that the highest court or the lowest court of competent jurisdiction under the Arbitration Act is a district judge's court, still it gave liberty to the High Courts to designate any court as the commercial court. So the intent, the legislative intent was that the commercial court as defined under the Commercial Courts Act should be the appropriate court because it is a later legislation. The second is the interplay between 2 special statutes, and insofar as this is concerned, the commercial court is a specialized statute set up for this purpose. So one special statute overriding another special statute, because arbitration is a general statute with regard to arbitrations, and there is a specialized statute relating to a specialized subject matter. And the third concept is a concept which I will request you to please see. This is a specific section in the Act, which is section 21, which gives overriding power. Section 21 of the Act gives overriding power to this Act. Please see section 21, Act to have overriding effect. Save as otherwise provided, the provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or in any instrument having effect by virtue of any law for the time being in force other than this Act. So any other law for the time being in force, Arbitration Act is a law in force, and it appears that there is an inconsistency between section 2(1)(e)(1) of the Arbitration Conciliation Act, which relates to the definition of a court in domestic arbitrations and the definition of a commercial court. So commercial court will override that. So whenever there is a conflict between the Commercial Courts Act and the Arbitration Act, the commercial court will override. So a litigation which was pending before a district judge, being an application under various provisions of the Arbitration Act, it could be an application under Section 9 of the Arbitration Act. It could be under Section 9 for interim measures of protection. It could be under Section 15 or Section 14 for declaration and 15 for termination of the mandate. It could be under Section 26 and 27 for expert, appointment of expert. It could be under Section 34 for setting aside of an arbitral award. So these applications may have been pending in hundreds before the district courts, being the principal civil court of original jurisdiction. The moment they are transferred, they will be transferred to the commercial court, irrespective of the personnel manning the commercial court. Likewise, any new litigation will be filed in the commercial court, irrespective of whether it's a district judge's court or the judge or a civil judge senior division. Now, the judgment in this regard, which I was expounding on, is the judgment of JC Housing Private Limited. JC Housing Private Limited versus Registrar General Odisha. Because this is a matter where the same situation was there in the Odisha High Court, where the commercial court was the designated court of civil judge senior division, and this question arose. The citation is 2023, Volume 1, Supreme Court Cases 549. I just repeated, 2023, Volume 1, Supreme Court Cases 549. JCJAY JC Housing Private Limited versus Registrar General Odisha High Court. So this is a very interesting concept as to what happens in the interplay between two statutes. So now that we have come to grip with this, let us come to the important provision of the necessity of pre-institution mediation. What is pre-institution mediation and why must it be necessary? Because the courts have felt, and there is a judgment of the Supreme Court which has felt that it is not only the convenience of the parties that is important, but it is also important to see what is the convenience of the institution set up by the sovereign. The Supreme Court says that even if 1 in 100 cases are settled in mediation, even to that extent, the backlog of the civil courts is being reduced. So it is absolutely imperative that the parties must first go for mediation in all cases where there is no immediate necessity of interim measures of protection. If there is a necessity of any urgent interim relief, then of course I think this is God saying, speak less. Pre-institution mediation and settlement has been devised as mandatory. Mandatory because, as I said, not only the convenience of the litigants, but the convenience of the system of dispensation of justice set up by the sovereign. Now, how valid is such a law which restricts the right of a party from filing suit? Because a litigant, a plaintiff, has a cause of action. He has a right to sue. The subject matter on which he intends to sue, the pecuniary jurisdiction is above the specified limit. But still he is being barred from filing a suit if he does not go for mediation. And if he does not go for mediation, the suit is barred. Is this constitutionally valid? Is there not a right to sue which inheres in every citizen? The Supreme Court gives two examples and says, see, even in these situations, not that you don't have a right to sue, but you must comply with certain preliminary requirements before you can sue. And the two instances the Supreme Court gives is of Section 69 of the Partnership Act and Section 80 of the Civil Procedure Code. Now, as you are aware, under the Partnership Act, for a partnership firm to be entitled to sue to recover pay all my LIC policies. This is a very good way to make one miss all the thread of one's conversation. Section 12A is concerned, the Supreme Court says, see, a partnership firm cannot sue for recovery of its claims unless the partnership firm is registered. An unregistered partnership firm is not entitled to sue. This is a statutory restriction brought in by Section 69 of the Partnership Act. So even if there is a cause of action, there is the right to sue, but the statutory restriction is there, that you must get yourself registered before you sue. The second instance which the Supreme Court gives is of Section 80 of the Civil Procedure Code. If any person has a claim against the government or against the railways, notice under Section 80 has to be given. And the only restriction in Section 80 is in Section 80 subsection 2, where the Civil Procedure Code says that only in case of urgent relief, dispensation can be permitted of notice under Section 80. So here too, the law says that you get a dispensation from going for mediation only if there is a necessity of any urgent interim relief, otherwise not. So far as this situation of going for urgent interim relief is concerned, the courts have held that Section 12A, I come to 12A immediately, is not a mere procedural law. The design and scope of the Act, which has, of this particular provision, Chapter 3A, which has been brought in 2018, it was not there earlier, which has been brought in 2018, is to try and reduce the backlog, the huge backlog in the civil courts. And it is not as if that a person is being deprived of his rights, because so long as this mediation is concerned, it is continuing, limitation will not continue. So that is a benefit brought in, that so long as the process of mediation is continuing, the clock of limitation will not continue to run. So the plaintiff is not otherwise prejudiced. And if the plaintiff seeks interim urgent relief on an urgent basis, it can terminate the mediation and come back to the court. So here, if we go back to the Section 12 capital A, and if I may read the first subsection, says a suit which does not contemplate any urgent interim relief under this Act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as be prescribed by rules made by the central government. So shall not be instituted, it is mandatory. It is not may, it is shall. Cannot be instituted, an absolute legislative bar, a prohibition. And if you come to subsection 2, it talks of setting up the authority. Subsection 3 talks of mediation 3 months and further extension of 2 months by consent of the parties. And the second proviso is important because it says during this period that the mediation is going on shall not be computed for the purpose of limitation under the Limitation Act. Please have a look at subsection 5. Subsection 5 says what I had mentioned, that the settlement, if it does take place, it will have the same status and the effect as if it's an arbitral award on agreed terms in terms of subsection 30, subsection 4 of the Arbitration and Conciliation Act 1996. So although you have intended to go for a civil litigation, the legislature compels you to go for mediation, there is a settlement. That settlement automatically becomes an arbitral award, enforceable as an arbitral award. The provision on the face of it appears to be quite straightforward, but there are certain interesting nuances. Suppose, so far as I am concerned, a plaintiff, I have a dispute with somebody which is a commercial dispute and which ought to have been filed before the commercial court. But I don't want to go for this nonsense mediation. I don't want to get stuck up with this commercial courts act rigmarole. So I file a suit in the ordinary court. So I don't have to go for this pre-institution mediation. Then it is discovered, the court suo motu, or at the instance of the defendant, it's discovered that it ought to have been a suit filed in the commercial court. What is to happen to my suit? Can it be transferred? It can't be transferred. Similarly, I have a dispute which is not a commercial dispute, but I want my suit to be expeditiously disposed of. Therefore, I go for the fast track litigation, I file it in the commercial court. Not praying for any urgent litigation, any urgent relief, praying that I want an urgent relief, saying that there is an apprehension that the defendant is going to dispose of my property, or the defendant will secret or go away, or plead all those requirements of Order 38 attachment, or Order 39 injunction, or Order 40 receiver, making out a case of grave urgency. And I file it in the commercial court. Since I have pleaded urgency, I am not required to go for mediation. Now, once it's filed in the commercial court, either suo motu by the court itself, or at the instance of a defendant, it is found that this ought not to have been filed in the commercial court, but ought to have been filed in the ordinary court. Can it be transferred? Answer is no. The Supreme Court says the only remedy available is Order 7, Rule 10, under which the plaintiff is returned to the plaintiff for being refiled if he so desires in the appropriate court, or Order 7, Rule 11, where the claim can be rejected. Two questions arise. Two important questions arise. One question is, what is to happen to the court fees? The plaintiff has paid full court fees. Now, if the plaintiff is rejected under Order 7, Rule 11, does he have to pay the court fees again? Supreme Court says, bad luck. You have taken the call, you have taken the risk, court fees you will not get back. If it's Order 7, Rule 10, the plaintiff is returned, so you can utilize that court fees. But if the plaintiff is rejected as being barred by law, one of the grounds for rejection of plaintiff under Order 7, Rule 11 is barred by law. If the plaintiff is rejected, court fees you will not get back. The second vexing question is of limitation. Suppose the suit has been pending in the wrong court. You know what happens to limitation? In the meantime, the right to sue 3 years have passed. Then it is being refiled. The only way in which you can be saved is by applying Section 14 of the Arbitration Act, which gives an exemption during the time that the proceeding has been pending in a wrong court. So far as the law with regard to pre-institution mediation is concerned and its mandatory nature, the Supreme Court has given a very detailed judgment. Very detailed judgment. The judgment is Patil Automation Private Limited, Patil Automation Private Limited versus Rakeja Engineers, and the judgment is reported in 2022, Volume 10 Supreme Court Cases, page 1. 2022, Volume 10 Supreme Court Cases, page 1. Now there is one interesting rider to this. The section, if you read the section, says a suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff exhausts remedy of pre-institution mediation. A suit which does not contemplate, whose contemplation? Is it the plaintiff's contemplation? Is it the defendant's contemplation, or is it the court's contemplation? Who is to take the call? I am the plaintiff. I filed the suit. In my plaint, I have said there is immediate necessity of urgent interim reliefs because of the acts of omission and commission, or the apprehended acts of omission and commission of the defendant. I feel reasonably it is real, grave and imminent that some danger may happen to my property or to my rights, therefore I need urgent reliefs. Therefore I have contemplated the urgent reliefs and I have filed the suit as a commercial suit without going for pre-institution mediation as the law permits me. Then what happens is I file an application for injunction because I feel there is urgent reliefs, and then after 10 months when the injunction is rejected, at the instance of the defendant, am I to be non-suited? Because I had filed a suit claiming that there was urgent reliefs that I required, and the court has ultimately held that you did not have any ground to seek any relief at the interim stage, by way of injunction or receiver or attachment, whatever it is. Then what is to happen? Is my suit to go? Because is this a suit where I ought to have gone for mediation? And I deliberately filed it as a suit where urgent reliefs were required, and ultimately court has held that nothing was required. Let us take another case. I make similar pleadings making out a case of urgent relief, and then I don't file an injunction application at all. Can the defendant come back after 3 months or 4 months and say that he has filed the suit? He has avoided pre-institution mediation on the ground that he required urgent relief, and he has not filed an injunction application at all. Therefore, on the face of it, the suit should be dismissed as being in violation of Section 12 category. Very vexed question, answer to which it is actually difficult to think of. Because when the section is there and the section says a suit which does not contemplate, that means the contemplation is being done at the stage when the suit is being filed. It must naturally and obviously be the plaintiff's contemplation. Because it is the plaintiff who contemplates or envisages that there is need for some urgent protection. So the contemplation is not the court's contemplation, the contemplation is not the defendant's contemplation, but the contemplation is the plaintiff's contemplation. That is one aspect of the matter. The second aspect of the matter is, the plaintiff may have, at the time when he instituted the suit, felt that there was a need for urgent interim relief. But that apprehension may not continue. That apprehension may be assuaged by the defendant not actually taking any steps, which necessitates the making of an application for injunction or a receiver or attachment. Does he still need to file an application for interim reliefs? No, he does not need to. The law as it now stands, as settled by the Calcutta High Court, the Supreme Court had in this judgment, which I have given you the citation, the opportunity to go into this matter. The Supreme Court said this is not a matter which requires this consideration, so we are leaving this issue out. The Calcutta High Court has gone into this matter and said that the plaintiff's contemplation, if it has been accepted by the court at the instance of at the instance when the suit has been lodged, when the suit has been instituted, and the court has been satisfied at that instance when the suit has been instituted by acceptance of the plaintiff and by giving leave to file the suit, that there is in the plaintiff's contemplation a reasonable ground for thinking that urgent relief is required, then any later development will not change the nature and character, and the plaintiff cannot be non-suited. So far as this is concerned, this is a very recent judgment of 2023. The citation I can tell you it's 2023 SCC Online 2443. SCC Online Calcutta 2443. Very interesting two or three paragraphs. I just placed one of these paragraphs which answers the questions that I placed. Paragraph 11 of the judgment says, the legislature does not say that the relief should be urgently sought from the court, or the time period within which the relief is to be sought, or the nature of the relief to be sought to qualify as an urgent relief. The legislature has only mentioned that the suit should contemplate urgent interim relief. Then in paragraph 17 it says, so the test in my opinion, this different judgment, the test in my opinion is not whether an urgent interim relief is immediately required, but whether the averments in the plaint point to a situation where even before expiry of 3 months, the plaintiff may have the need to obtain interim relief. 3 months is the period of mediation provided under 12A. And finally it says, in my view, the expression an urgent relief is contemplated signifies the inbuilt case in the plaint, from where it could be inferred that in all likelihood an interim relief may be required in the period of 3 months. More importantly, appreciating the case of the plaintiff in the plaint, a learned judge of this court exercising interlocutory jurisdiction granted leave to the plaintiff under section 12A. It is to be presumed that the above factors were considered by the learned judge while granting leave. In my view, when such leave has been granted, it was not proper for any other single judge without any change in facts to revoke it. So as I said, when at the time of institution of the suit, the court has been convinced, the judge who was taking up the matter at that point of time has been convinced and allowed the suit to be instituted. Later on, after 10 months, when the injunction application is dismissed or no injunction application is filed, another judge ought not to revisit and revise that suit and irreparably prejudice the plaintiff by non-suiting it. This is the situation with regard to pre-institution mediation, and there is a huge amount of litigation with regard to pre-institution mediation. Huge amount of litigation also with regard to transfer proceedings, which I mentioned. Transfer, as I said, if it is instituted wrongly in a wrong court, after it ought to have been filed in either the commercial court or the ordinary court, transfer is not permitted. Order 7 Rule 10A or Order 7 Rule 11. Transfer provision is there in section 15, and the courts have explained why the transfer provisions will not apply. Please come to section 15. All suits and applications, including applications under the Arbitration and Conciliation Act, relating to a commercial dispute of a specified value pending in a high court, where a commercial division has been constituted, shall be transferred to the commercial division. All suits and applications, including applications under the Arbitration and Conciliation Act 1996, relating to a commercial dispute of a specified value pending in any civil court, in any district or area in respect of which a commercial court has been constituted, shall be transferred to such commercial court. The catchword here is pending. The suit has to be pending on the date when this act came into being. It is only those suits which will be transferred. If the suit has been pending either in the High Court or in any district court on the date when this act came into being, then automatic transfer in terms of section 15. Section 15.1 and section 15.2 both talk of suits and applications pending. One in respect of High Court and in subsection 2 civil courts. So if the suit was not pending, if it is a later suit, the examples we were discussing, the later suit filed in order to avoid the rigors of the Commercial Courts Act or in order to take advantage of the Commercial Courts Act, either way, then they will not be transferred. Then you suffer the ignominy of having your suit dismissed. You've taken the chance, you've taken the peril, you must suffer from it. There is one interesting issue here, that is with regard to extension of time to file written statement. As you are aware, in terms of Order 8 of the Civil Procedure Code and Order 5 of the Civil Procedure Code, amendments have been carried out. And in terms of both these amendments, the time to file written statement has been severely restricted, 30 days and maximum of 120 days. So 30 days plus 90 days, beyond which the defendant loses the right. The legislature uses the expression shall forfeit the right to file written statement. So if the right is forfeited, the right stands extinguished. There can be no further condonation beyond the 120 days. That is also applicable to commercial courts. Except that one rider, this is not applicable to transferred suits. That you will find in subsection 4 proviso. proviso to sub-rule 1 of Rule 1 of Order 5 of the Code of Civil Procedure, which gives the timeline for filing written statement, shall not apply to such transfer, suit or application, and the court may in its discretion prescribe a new time period within which the written statement must be filed. So if the suit has been transferred from an ordinary court to the commercial court, in the meantime 120 days is over, there is discretion still vested in the commercial court to extend the time. So this is one benefit which the litigant gets out of the transfer. Before I come to the provision of appeals, I must come to a very important part of the Commercial Courts Act, which is the amendments made to the Civil Procedure Code. When the Commercial Courts Act came into being, it really laid down the procedure, and it laid down the procedure to earmark certain provisions which were creating roadblocks in the way of quick disposal of suits, particularly in the Civil Procedure Code. So what the legislature did was that it amended the Civil Procedure Code itself. Now when we have the Civil Procedure Code, what we get is the Civil Procedure Code as amended by the Commercial Courts Act. But the Civil Procedure Code as it originally existed, 1908 Civil Procedure Code as amended in 1976, that is applicable to all ordinary litigations. But the amended provisions of the Civil Procedure Code would apply to the Commercial Courts Act. And some very, very important provisions have been added or subtracted. And the legislative power to do that comes from section 16. If you please come to section 16, it gave the power to apply the provisions of the amended Civil Procedure Code. Section 16 says amendments in the Civil Procedure Code in its application to commercial disputes. The provisions of the Code of Civil Procedure 1908 shall in their application to any suit in respect of a commercial dispute of a specified value stand amended in the manner as specified in the schedule. Then please see 3. Where any provision of any rule of the jurisdictional high court or any amendment to the Code of Civil Procedure by the state government is in conflict with the provisions of the Code of Civil Procedure 1908 as amended by this code, the provisions of the Code of Civil Procedure as amended by this code shall prevail. So the amended CPC now has overriding powers. It supersedes anything contrary, anything repugnant, anything which is not in tune with the amended CPC. Now in the bare Act itself, I am sure after the Act ends, you will find several provisions of the CPC which have been altered, which are applicable to the Commercial Courts Act. If you please turn the pages over, there is a schedule, and underneath the schedule it says refer section 16. Just after section 23, which is the repeals and savings provision, there is a schedule. Is it there? So there is a schedule, refer section 16, and then the provisions of the CPC which have been amended and are now applicable are mentioned here. The rest of the CPC will obviously apply, but these provisions will apply in the place of the provisions which have been replaced. These will apply. So one is in section 26. Section 26 is important because of the manner in which the affidavit has to be done. You will find that the provision of Order 6, Rule 15A has been set out here. It requires a very specific form of affirmation of the affidavit, including what is now known as a statement of truth. Then 35 costs. Now in the original CPC, the provision for cost was very perfunctory. Now you will find that there are different categories under which costs can be awarded. And please see the manner of determination, whether costs are payable, quantum, when are they to be paid, and cost, please see what it includes. It's not just an expensive assessment in a very arbitrary fashion. One must take into account, the court must take into account, kindly see 1, 2 and 3, fees and expenses of the witnesses incurred, legal fees and expenses incurred, any other expenses incurred in connection with the proceedings. So all this the court will have to take into account at the time of awarding costs. And please see 3. In making an order for the payment of costs, court shall have regard to the following considerations: whether party has been taking repeated adjournments, whether the witness has not been coming for various reasons. So A is the conduct of the parties. B is whether a party has succeeded on part of its case even if that party has not been wholly successful. Then if there is a frivolous counterclaim, reasonable offer to settle was unreasonably refused, then party made a frivolous claim, instituted vexatious proceedings. So all these acts will have to be taken into account. Then the order for costs, what will it include? That is in subsection 4. There is a very important addition in this because the others are something we all deal with, but please see D, costs incurred before proceedings have begun. So even this will have to be taken into account. Then very important portion is the schedule, which is the schedule for filing of the written statement, which I have already mentioned as order 5, rule 1. Then order 6 is with regard to form of pleadings. 15A is verification of pleadings. I mentioned statement of truth, remember, that is in 15A subsection 5. This has been made mandatory. The court may strike out a pleading which is not verified by a statement of truth, namely the affidavit set out in the appendix to this schedule. It has become mandatory. Now, because of this, there are other substantial changes to the Civil Procedure Code also. If you have a look to the Civil Procedure Code, the grounds for rejection of the plaint there have been several amendments here. So it has been expanded from what it was originally ABCET. Now, interest is another provision where detailed provisions have been made. Then if you come to order 11, which is part of the schedule, the entire order 11 has been changed. Discovery, inspection of documents, production of documents, interrogatories, everything has been changed. It's a new substituted provision. Order 11 is entirely different from what it was previously. Now with the advent of technology and the amendment to the Evidence Act and the new the Information Technology Act, we have provisions incorporated here with regard to admission of electronic records, which is very important because now this is the thing. One has to, while either being a lawyer or a judge, deal with electronic records. Amendment has been brought in the Evidence Act by way of section 65B. Here also if you see in the order 11, rule 6, electronic records and how to prove this has come in. So the declarations have to be in the form provided here. This is a very important amendment to ensure that the furnishing of printouts, every day we are dealing with printouts. We often get printouts from banks saying signature not required, from various authorities saying signature not required. They have to be proved in a particular form and fashion. That is provided by order 11, rule 6, read with section 65B of the Evidence Act. Then the provision that I was mentioning, that is the provision of summary judgment. As I said earlier on, there were only two provisions under which summary judgment could be given. One is judgment on admission, order 12, rule 6, or chapter of summary judgments under order 37. But they were concerned with defenseless provisions. In Order 12 Rule 6, when the admission is categorical, clear, unconditional, decree can be passed. Similar situation with summary suits, where leave is not given to file a written statement, or leave is given only on condition of putting in money. Have a look at Order 13 capital A and please see the ramifications of how a summary decree can be passed in a commercial dispute. Please see Rule 3 of this Order 13A. This is an absolute new concept and it's absolutely novel. 3. Court may give summary judgment against the plaintiff or defendant on a claim if it considers that A. The plaintiff has no real prospect of succeeding on the claim, or the defendant has no real prospect of successfully defending the claim as the case may be. And B. There is no other compelling reason why the claim should not be disposed of before recording of oral evidence. So this is a new dimension being brought in to summarily disposing of matter. The judge, on his subjective satisfaction, comes to view that there is no real prospect of the plaintiff succeeding or no real prospect of the defendant succeeding on his defense. And there is no other compelling reason why I should keep it on the board any longer. Then I pass a summary judgment. Now what can the court do is in Rule 6, orders that may be made. Judgment on the claim, conditional order in accordance with Rule 7, dismissing the application, dismissing part of the claim, and a judgment on part of the claim that is not dismissed, striking out the pleadings or further directions to proceed for case management. Then in the conditional order you will find that deposit of money can also be directed. If you see Rule 7 and you see Rule 7 sub-rule 2a small I Roman 1, on the basis of the judge's discretion and subjective satisfaction that there is no real prospect, it gives no objective guidelines. The subjective satisfaction that there is no real prospect, the party can be directed to deposit money in court. Earlier on, deposit of money could be only for attachment in terms of Order 30 Rule 5. Now, only on the concept of there being no real prospect, money can be directed to be deposited. 3. Security, and 4. Impose other conditions. So these are really draconian provisions which are coming, giving large discretion to the judge to put his stamp on the litigation by saying, I want that this has to be done. And then ultimately, Order 15A, which is really the icing on the cake, case management hearings. Please see orders to be passed in case management hearing, which is part of Rule 2 of Order 15 capital A. With regard to every aspect of the matter, separate orders are to be passed by the court, fixing time limits. So in Rule 2, in A you have framing of issues, in B listing of witnesses, C fixing of date by which affidavit of evidence is to be filed, D fixing of date for adducing of evidence, E fixing of dates by which written arguments will be filed, then F fixing date by which oral arguments are to be heard, G setting time limits for parties to address oral arguments, and completion of the trial, please see Rule 3, not later than 6 months from the date of the first case management hearing. So when does case management hearing start? Please come back to Rule 1, not later than 4 weeks from the date of filing of admission of affidavit of admission and denial. So not later than 4 weeks of filing of the affidavit of admission and denial. And when must the suit come to an end? Not later than 6 months. So this is a mandatory fixed time frame fixed by the legislature. Arguments must be closed not later than 6 months. So start date is not later than 4 weeks, not later than 4 weeks, so not less than 1 month. So filing of affidavit of admission and denial plus 1 month. Case management starts. Case management starts 6 months, arguments must close. So the entire duration of a trial from the time of order 11, that is affidavit of admission denied, to close of arguments is 6 plus 1, 7 months. Suit is over in 7 months, which used to be over in not less than 7 years. The suit is over in 7 months. And with regard to powers of the court in case management hearing, enormous powers. In Rule 6, enormous powers. Please see Rule 7, court will not adjourn. And where the party fails to comply with the orders passed in case management, draconian forfeiture orders are there. It can be costs, foreclose the non-claimant's right to file affidavits, conduct cross-examination, foreclose the right to cross-examine, foreclose the right to file written submissions or address oral arguments also, or the right to make further arguments or dismiss the plaint. So draconian powers have been given to curtail the time and to ensure that the oft-quoted phrase that we hear in movies, "Tarikh pe tarikh," does not take place insofar as proceedings under this Act is concerned. So this is really a brief overview of the statute. One provision that I left out is with regard to section 13, which is the transfer provision. As I mentioned, 13 also is very, very restricted. The provision has to be there in order 43 if it is a suit, and the provision has to be there in section 37 if it is an arbitration proceeding, otherwise no appeal. Please come to section 13. 13 subsection 1 and subsection 1A is the substantive power. Now please see the proviso. Provided that an appeal shall lie from such orders passed by a commercial division or a commercial court that are specifically enumerated under order 43 of the Code of Civil Procedure as amended by this Act and section 37 of the Arbitration and Conciliation Act 1996. In order 43, there is a list of orders from which an appeal can be preferred and no others. In section 37, likewise, there is a list of orders from which an appeal can be preferred and no others. So, if it is not there, then you cannot prefer an appeal. And this, in conjunction with the provision in section 10, in section 8, please come to section 8, which is the bar against filing a revisional application also. Section 8 says, notwithstanding anything containing any other law for the time being force, no civil revision application or petition shall be entertained against any interlocutory order of a commercial court, including an order on the issue of jurisdiction. And any such challenge subject to the provisions of section 13 shall be raised only in an appeal against the decree. So the entire plethora of civil revisions and appeals which inevitably delay the proceedings are absolutely done away with. And there is a clean slate in which litigant knows the date of institution, the date of the various case management hearings, the moment the affidavit of admission and denial is filed. Within 1 month, trial starts by way of case management. 6 months, it's over. So 6 plus 1, 7 months, I have a decree or my suit is dismissed. No appeal, no revision in the interim unless it's in order 43 if it's a suit, or in section 37 if it's an appeal. Now, so far as the restrictive power of the courts, insofar as appeals is concerned, there is a landmark judgment of the Supreme Court here also. The judgment is Kandla Export Corporation versus OCI Corporation. The citation is 2018, volume 14, Supreme Court cases 715. This is Kandla Export Corporation versus OCI Corporation, 2018, volume 14, Supreme Court cases, page 715. This lays down the restrictive nature of the appeals. On appeals, there is only one additional aspect that I would like to dwell on before I complete the appeals chapter. You will find that in section 13, which I was going through just now with regard to order 43 and section 37, there is a time limit prescribed there. Both in section 1, which deals with appeals at the district judges level, and 1A, which deals with the appeals at the commercial appellate divisions level, there is a period of 60 days. You will find that there is a period of 60 days provided there. You have seen that 60 days period is there. Now this is different from what is there in the Limitation Act. Limitation Act, insofar as appeals is concerned, it is, if it is from one court to another court, it is 90 days, and if it is an inter-court, it is 30 days. So the limitation so far as appeals under the Commercial Courts Act is different from the limitation provided in the schedule to the Limitation Act 1963. So the question is which limitation will prevail, and the Supreme Court has said that so far as this is concerned, the Commercial Courts Act will prevail. To that, the Supreme Court has added that obviously section 5 will apply. But the Supreme Court says that in construing section 5, one should see that the period of delay is not longer than the original period provided in the statute. This is a new concept which Supreme Court brings in, because it was never the case. The law always was that every day's delay is not relevant. One has to see that the meritorious case is not thrown out at the threshold because of technical considerations. So one was always liberal with section 5 concept of sufficient cause. But now the Supreme Court says, please see that the period of delay is not longer than the period provided for doing the particular act, that is the appeal. If the appeal provision provided 60 days, the period of delay should not exceed 60 days. What happens if it does exceed? The Supreme Court says that if it is within 60 days, granting condonation is a matter of what is the usual course. But if it exceeds, then granting condonation is the exception and not the rule. So now the Supreme Court in 2021 carves out an exception from what we always knew to be the law, that if the period of delay exceeds the original period, granting condonation will be the exception and not the rule. Within the period, it continues to be liberal. The judgment in this regard is State of Maharashtra versus Borse Brothers, and the citation is 2021, Volume 6, Supreme Court Cases 460. 2021, Volume 6, Supreme Court Cases 460. So this is a little, the law is slightly tweaked by the Supreme Court for the purposes of expeditious disposal of matters under the Commercial Courts Act. So this in brief is so far as what the Commercial Courts Act leads us to, and I dare say it makes a substantial difference in so far as the litigant is concerned, as well the lawyers as well as the judges, because these are concepts which we were not accustomed to, particularly the concept of case management hearings, the concept of fixation of timelines, new provisions which are there, which have been brought in by way of amendment to the Civil Procedure Code, are new concepts. Now what we have to do as lawyers or as judges, we are dealing not only with one sort of, but both types of litigations. We will be dealing with both commercial litigations under the Commercial Courts Act and ordinary litigations under the ordinary procedure of the Civil Procedure Code. So there is a complete dichotomy between the two procedures which are followed. One has to be very careful to see that one does not mix up the two concepts while dealing as a lawyer or as a judge. And the trend is to remember what we knew when we were growing up, and it is very difficult to incorporate the new and the novel concepts which are being brought in by the legislature as part of the odd concepts which have already been ingrained in our memory. particularly with regard to Order 11, Order 14, Order 15, 15 capital A, concepts are absolutely new. So it is imperative that these concepts must be gone through again and again, particularly the amendments to the Civil Procedure Code, because they affect everyday's proceedings and everyday's procedure in the court. This is so far as what I needed to discuss with regard to the Commercial Courts Act. If anybody has any questions, I'll be happy to take them. I'm not very sure I'll satisfy everybody, but to the little extent that I know and I've been able to read through, I think I have covered most, if not all, the judgments that the Supreme Court has come up with. If any judgment is there of the Supreme Court which I have not touched, it is by way of inadvertence. But I think I have covered most of it. There are some judgments of the Sikkim High Court also with regard to the Commercial Courts Act, and judgments which are in tune with the judgments of the Supreme Court. In fact, the substantial judgments are there of Bombay, Delhi, Madras. As you know, Calcutta, Bombay and Madras were three presidency towns, so they had three chartered high courts. These three had the original jurisdictions. Then thereafter, we have had original jurisdictions added to the High Court of Delhi and Himachal Pradesh. So we have now original jurisdiction in Calcutta, Bombay, Madras, Delhi and Himachal Pradesh. So far as Calcutta, Bombay, Delhi and Madras are concerned, they are restricted within specified territories. So far as Himachal Pradesh is concerned, the entirety of the state is covered by the original jurisdiction of the Himachal Pradesh High Court. So far as these high courts are concerned, within the territories over which they exercise jurisdiction, there is the commercial division. Insofar as other states are concerned, where the High Court does not exercise original jurisdiction, we have the commercial courts. Commercial courts at the level lower than the level of the district judge. From there you have the commercial appellate court. Insofar as the High Courts are concerned, the original jurisdiction is the commercial division, because the High Court is there as the original court where the trial is held. From the commercial division, one goes to the commercial appellate jurisdiction. The law and the procedure remains the same, except for the courts which have original jurisdiction. The trial is in the High Court itself by the commercial division. The second stage is known as the commercial appellate jurisdiction. So far as other states are concerned, where there are district courts, even in Calcutta, even in Bengal, Maharashtra, there are district courts. There also there are commercial courts, commercial appellate courts. So this is the hierarchy. We have, as usual, we have two hierarchies in the state, and ultimately one goes by way of Article 136 to the Supreme Court. So this is in essence the Commercial Courts Act. And thank you very much once again for your immense patience. And I am extremely sorry for having drawn you out during your holiday. It is not the in thing. I would have been very aggrieved if I was going to work or come to a workplace on a weekend. I am extremely sorry. And next time the learned director requests, I will be happy to come on a weekday and talk to you. And my gratitude once again to the learned director of the academy for the indulgence that you have given me and for the extreme care that you have taken with all aspects of my youth.
You have come to